All right, thank you everybody for coming in this evening, despite the rain and storm that's brewing out there. I appreciate you coming. We have an exciting and informative topic today. We're going to be starting off talking about the eviction process, and we have Jeremy Schwartz who will begin that presentation. All right.
Okay. Thank you. I'm Jeremy Schwartz with Utah Eviction Law. I've seen a few guys around at different UAA things at a trade show. You guys have a booth there, so feel free to stop by and say hello. There's a few of the things that our firm does. Well, not a few of the things. That's pretty much all we do. And the nice thing is I'm not the type of attorney that you come in and ask me a question, and I'm busy enough with these things to where if it's outside of those, I'll try to get you a good referral to somebody else. But that's pretty much what we do there. We have a monthly newsletter that we email out. If you want to get that, it's completely free. We don't do anything else with your email address, but if you'd like to sign up for that, just throw in your name and email address here. I have to apologize because, yes, I am sharing this with a 2-year-old, this iPad, so this cover was beautiful before he started sharing, but he doesn't do too well. So you just want to pass that around. We wanted to talk about the eviction process. Avoiding evictions is the better way to go, but once you're in the middle of a problem, we wanted to walk through that so that you can help to get through it as quickly as you can and as painlessly as you can. I don't know if you can see down at the bottom in the very back, but you're going to be hearing plenty of free legal advice and war stories, and we're going to start out with one that's really important. Don't rent to Rosalind Fiedler. If you ever see that name, do not rent to her. She has 18 prior evictions. I wouldn't mind personally doing number 19, but just so you know, Rosalind Fiedler is a no-go. I had a potential client call in and say, she just moved in and been horrible at paying rent from the beginning. And as soon as that happens, I say, well, you know, what's their name? I can do a quick background check since you probably didn't. And we'll see if I can find anything. And he said, oh, it's, what is it? It's Rosalind. You don't hear Rosalind all that often. And he was stumped. He couldn't remember the last name. And I told him, I said, don't say Fiedler. How'd you know? I'm like, let's see how many she has now. So she's up to 18. Don't do it. A couple of general pointers about lawsuits. There are 2 questions that you want to ask prior to any lawsuit. Number 1, are you going to win? Do you have a successful claim? Don't get involved in a lawsuit you're going to lose. Right? And number 2, are you going to be able to collect once you get a judgment in place? And you want to say yes to both of those. But evictions are a little bit unique. Even if you can't say yes to number 1, you want to say yes to number 1. Are you going to win? Yes, you want to get involved in an eviction only if you're going to win. But even if you can't collect, an eviction is going to help you to stop the bleeding, get them out, get a new renter in there that's going to pay, and you need to regain control and possession of your property. So those are 2 big advantages. Even if you're never going to be able to see a dime from them on the collection side, you still need to get them out, stop the bleeding, regain control and possession of your property. A couple of quick pointers about evictions and collections. An eviction is when you've served a notice, they violated it, and they're still in the property. They didn't leave within that timeline. A collection is you take that eviction notice. They still owe a balance. They might have moved out. They probably have. And there's a balance owed. That's what a collection is. If you can pick between those 2, if you're interested in trying to collect, please treat it as an eviction. An eviction is going to be better because of speed. The amount of the judgment is going to be higher because in an eviction you're entitled to treble damages, so we can triple certain charges. And service. How many of your tenants that owe you money for rent and damaged your property are very willing to give you, well, here's my accurate forwarding address. You need to serve them with court papers if you're going to do something, and it's a lot better to do it while they're still in your property because I know how I can serve them. A couple of general pointers about evictions. They deal with 2 issues. Number 1 is possession of the property, and the second item is damages. And even if you need to keep them separate, if they leave and possession is figured out, there's still the damages issue. Have you ever had a tenant that you give a 3-day pay or quit, and they decide, well, I'm not going to pay, so I'm going to quit, so they leave in the 3 days. Well, I don't know anything because I complied with the eviction notice. There's no balance owed. I quit. I left. It's not how that works. There's still a balance that's owed. So keep those separate. There are only 2 ways to get somebody out of your property. 2 legal ways. There are other ways, but they involve lawsuits from the tenant to the landlord, so you want to be careful of those. The 2 ways to get somebody out of your property: number 1, they voluntarily leave. That includes an abandonment or a cash for keys, but they voluntarily leave. It can be with some discussion, with some negotiation, but they're the ones that move out. If they don't voluntarily leave, Utah law requires you to go through the court process. So you have to go through that. You don't have any options, any legal options. You do have some other options, but they can involve a lawsuit. Each eviction has to follow these 3 steps. Number 1, give eviction notices. And I put plural on there because if you have multiple violations, please give multiple eviction notices. It gives us the opportunity to talk to the tenant about multiple grounds for the eviction. If you only do 1 eviction notice, I have 1 bite at the apple. If you give 5 eviction notices, I don't have to prove 5 eviction notices. I just need to prove 1 of them. And I have a story that there was an eviction where I was nervous about it. The landlord got the speech that this might go south on us because there was a difficult case. And when we got into the hearing, before we talked to the judge, I grabbed a conference room and just started talking to the tenant. And I laid out 5 different eviction notices. And I said, I know you dispute each and every one of these, but I don't have to prove all 5 of them. I just need 1. So do you really think that, let's say the judge disagrees with you on number 1. What about number 2? Let's say you win number 2. What about number 3? I only have to get 1 out of 5. And I was nervous about it, but that got the tenant's attention. Okay, maybe I'll settle. Great, thank you. Because it really helped us. And then instead of getting in front of the judge and arguing the case, we got in front of the judge and said, Your Honor, we've spent some time out in the hall. We've resolved it. This is what we've agreed to do. Then the judge doesn't have to make a decision on it because we've done that for him in our favor. So step 2, file the eviction with the court. As soon as they've violated an eviction notice, we can file the case. And number 3 is an eviction hearing. They're only usually required if the tenant disputes the eviction. So we don't always have to do that. If they don't fight it, then we can handle everything in step 1 and 2. And you want to be careful. Do not change the locks unless you've completed all of the necessary steps. And I didn't say all 3 steps because we can a lot of times skip that 3rd step. Who can serve an eviction notice? Anybody that's 18 or older, including the landlord. So there's not a restriction on you serving your own notices. I think if you're concerned about it, I think it's better to have a 3rd party do it or have a witness with you or something, but there's no restrictions on that. Legally, under the law, 18 years of age or older, and it can include the landlord. For me, this is my recommendation to any landlord for serving an eviction. Knock, post, and picture. Attempt personal service, knock on the door. If they answer, hand it to them. You're done. If they don't answer, post it on the door and take a picture. You're not required to take a picture, but I've had a couple of cases where the tenant claims, well, I didn't get a copy of it. Your Honor, I'd like to introduce you to Exhibit A. It's a picture, even from the cell phone, of the landlord that shows that it was posted on the property. Now it's not our word versus theirs. We've got a picture that shows it. Don't email it, text it. Verbally, you can't give eviction notices. You can't slide it under the door, inside the unit mailbox, none of that. Your options are personal service, posted service. You can send it by certified mail, but please don't. The reason is when does the 3 days start? And if they know what's coming, they're just not going to sign for it. So 3 weeks later, you get the eviction notice back in the mail saying they didn't sign for it. And now we have to go do the knock, post, and picture. And it takes us about 2 to 3 weeks to do an eviction anyway. So I always tell my clients, don't bother with certified mail. It's better to just send somebody over there first. These are generally the types of eviction notices. And the pay or quit is up there first. That's the one that you probably deal with the most. Have a quick pop quiz on eviction notices. How many days for each notice? That top group is all 3-day notices, and they're 3 calendar day notices. This second one there, the second section, tenant at will is a 5-day notice, and we'll talk about what a tenant at will is. And then no cause lease termination is a 15-day notice. So if you're terminating a month-to-month lease with the entities, it's a 15-day notice. But I know when I say 15 days, everybody says, well, 30, what is it? So what if your lease says a longer time? Go with your lease. And that's fine. The UAA lease, my lease says 30 days. So if you're terminating a lease, you want to go with 30 days. What if your lease says a shorter time? Don't go with that. I don't want to go shorter than what the law allows, but if your lease goes longer, then you need to comply with that. And so my lease and the UAA lease, it goes with the shortest timelines allowed under law. But if you give a 3-day pay or quit and the tenant has good communication and you feel comfortable with the payment plan that they're proposing, you're fine to work with them on that. We'll talk a little bit more about it. if it's, in a quick example, if the eviction notice is served Tuesday at 7 a.m., when do they have to comply? The day of service is always out. That's basically day 0. So they'll have Wednesday, Thursday, Friday at midnight. It's not a 5 p.m. Friday at midnight. They need to comply with the eviction notice, depending on what notice it is. And in this case, courts are closed Saturday and Sunday. Monday, we would be able to go on to step 2 and file the eviction with the court. So, let's talk about some of the different types of eviction notices. This is probably the most common one. This is the most of our evictions that we file are based on that 3-day pay or quit. It has to be a pay or quit. There's a lot of landlords that say pay and quit. I want you to pay and I don't want you here, get out. That's not a legal notice. That would get an eviction dismissed very quickly and very easily. The tenant only has 2 options to comply. Pay the entire balance or vacate within 3 days. And that's it. They don't have any other options. If your lease waives their right to pay, it's not enforceable. So this is an example of how it'll work. You've got your tenant that doesn't have any money, so the rent is 1 day past due, and please check your lease. In my lease it says rent is due on the 1st and late on the 5th, so when can you serve an eviction notice? Well, when rent is past due. It's due on the 1st, there's no late fees. Now here's one thing that I've done in my lease that I think helps clarify it. It's past due, and so I think that you can do an eviction notice on the 2nd. I think that's really aggressive, right? I wouldn't suggest doing that unless there's some weird circumstance where the tenant's just really causing problems. But a way to fix that is in my lease it says an eviction notice may be served on the 2nd. So that takes out a lot of that gray area. I still wouldn't recommend that, but at least gives the landlord an option, because you have those certain tenants that are being extremely difficult, and you'd like to be able to give them an eviction notice a little bit earlier. If your lease allows for it, that definitely helps. That's not a standard practice thing, right? I would definitely work with tenants. That's the better option. Give them some time. But I like having that saying when your rent is due and when it's past due and when you can serve an eviction notice. So they're late on the rent, you give a 3-day pay or quit. Can you see that? I was so proud of this website that I found that did my eviction notice for me. Pay or quit eviction notice. You'll be sorry if we hire Utah eviction law to get to evict you, so I'm mad landlord. So that's what you'll serve them with. And they have 3 calendar days to pay and they become model tenants, or they have to leave. And they have to pay everything, and if they just pack up and leave, there's still that balance owed. It would be treated as a collection case. So what can be included in the 3-day pay or quit? The statute says rent and other amounts due. And so the question is, you've got these types of different things. Obviously rent can be included, but what about these other charges? For me, the best thing to do is use your lease to define what the tenant is responsible for and what is defined as rent or other amounts due. The UAA lease is awesome on this. I had an eviction that the client asked me to do on a security deposit. Judges don't mind doing an eviction on rent. They are not real big on doing an eviction on a security deposit. And so when this client asked me to do it, there were some other problems as well, but we started talking about the security deposit that was owed, and it had been owed for months. They couldn't pay everything when they first moved in, and so they set them up on a payment plan. And 4 or 5 months later, they'd been paying the rent, but they were still woefully deficient in the deposit. And so I gave that client the speech that I don't like to give, I don't have to give it too often, that, hey, just so you know, we might lose this, and I'd much rather tell you that before we ever get involved in this, because I don't want to have to be embarrassed if we lost it. And so I gave her the speech, we might lose, and she said, well, I will still want to try. We got it in front of the judge down in West Jordan, and as soon as he found out it was a security deposit eviction, he almost just dismissed it right then and there. But I said, Your Honor, and I had my book out, I said, can we read the statute? And I think just to get me to be quiet so that he could then dismiss my case, he said, okay, fine. Pulled the book out, and he read the part, and I said, rent and other amounts due. And I said, Your Honor, it's a UAA lease. You look at it actually defines, rent is considered rent, late fees, security deposits. I said, really, legally under the contract, it's considered rent. But even if it's not, Your Honor, it's rent and other amounts due. And so if I can prove that it's due under the lease, that is an amount that can't even be included on a 3-day pay or quit. We did that, she didn't comply, we're entitled to an eviction. Him reading the statute flipped him 180 degrees. And, yep, that sounds right, Mr. Tenant, you're gone in 3 days. And so it's still risky, but I think that having a good lease that clearly identified what was rent and what's due saved me in that situation, or else I think the judge probably would have thrown it out. So that shows you how important the lease is there. What about partial payments? If they offer a payment in full within the 3 days, you must accept it. You're obligated to accept it. If they offer a partial payment or full payment outside of that 3 days, then you can reject the payment, the eviction continues. You can accept the payment, and the eviction is canceled. So it would be, you'd have to start over and give them a new eviction notice. My rule is generally 1 month of rent is usually a no-brainer. Take it, you can give a new eviction notice the next day. Make sure you're getting your funds certified, right? And you don't want to accept a personal check, give them a 3-day notice, stop payment on that check. That creates an additional problem, so you want to be careful there. But for a month of rent, that's typically a no-brainer. If it's less than that, you just need to decide what's worth it to you to start over. The nice thing about a 3-day pay or quit, if they offer a partial payment, you have to start all the way over. Well, if you just started it yesterday, it's not that big of a deal. Do you have a question?
We have our residents to pay, deposit the funds directly in the bank account, in our bank account. So if they make a partial payment and we don't want to accept it, I presume we just write them a check and return it.
I would do 2 things. Number 1, immediately communicate to the tenant that you've decided to reject that partial payment. Let me back up. I'd do 3 things. The first thing I'd do is, here's your 3-day pay or quit. We will not accept partial payments without approval. And have that in writing so that they clearly understand that. Number 2, as soon as it happens, I would clearly communicate to them in as many ways as reasonable to make sure that they got it, you're rejecting that partial payment. And let them know, and this is the 3rd item, as soon as those funds have cleared, if it was a cash payment, then that's really easy. If it's a personal check, they might be waiting a week or 2 to eliminate that right, their opportunity to stop payment on it before you refund that check. You don't want to immediately give them a good check out of your account, have them cash that, and then do a stop payment. Now you're in a deeper hole than you ever thought you would be in. So you want to be careful with that.
So would the best thing be to take cash only?
Certified funds. Cash, one of the problems is I deal with, every now and then something comes up, well, I paid that in cash.
Yeah.
I can honestly say, I've had some clients pay me in cash. I can honestly say I've never accepted cash without some form of documentation. I have a receipt book in my office, and I've had a couple, I met one client for lunch, and he was paying a retainer, and he laid out in the middle of a Del Taco $2,000 for some work that we were doing in hundreds. And I'm like, and what I did is I counted it so we both knew, and then I pulled out my cell phone and I said, "Dear Mr. Smith, just to confirm, you paid me X amount in cash." And so I don't take my receipt book to Del Taco. That was probably the last I went to Del Taco. But anyway,
And that
so
would
document
serve
it.
as receipts. That would be a documentation.
Yes.
That they got it.
Yeah, try to create a paper trail with that.
I missed the second thing you said. The first one was to let them know you reject the payment. What was the second thing?
The second thing is to make sure that they're certified, the funds are in your account before you refund it back to them.
So you emailed him that
Yes.
information?
Yes.
Not text, but email.
Email's easier to see a history and print it off and document it on your computer. So, partial payments in action, just a real quick example, and I found that it just reminded me of a lot of my clients that have tenants that are telling them, "Oh, just give me another day and I'll pay you." And then the next day, it's like that on the side of Joe's Crab Shack, free crab tomorrow. I'll pay you tomorrow, and that's kind of how a lot of my clients feel. But rent is past due, 3-day pay or quit. You accept that payment, and it just loops right back around. You need to reserve a new eviction notice. It starts the entire process over, which isn't a horrible thing a lot of times. You got your payment, and it only started a 3-day process over. You're not too far into it. Common defenses to a 3-day pay or quit. Notices for the wrong amount, so be accurate there. It was served improperly, so make sure you have a witness or documentation or picture, something to verify that. The tenant offered the payments and they were declined, or the tenant is withholding rent because the landlord has failed to make repairs. That is not acceptable unless they've complied with the Utah Fit Premises Act, and they probably have not.
Which is what?
That if there's any problems with the property that the landlord needs to legitimately repair, they have to give the landlord a notice of deficient conditions outlining the problems and give the landlord an opportunity to fix those problems. If the landlord doesn't, then under the law, they may be justified to withhold that rent. But in order for that process to even start, the tenant has to be in full compliance with their lease. So that has to happen before they're late on the rent. That happens a lot where they get the cart before the horse where, well, I'm late on my rent. So, hey, Jeremy, you know what? There's been a leak in the shower and it's damaging it and I can't live there, and that's not how that works. They've got to be in full compliance with their lease before and give a notice of deficient conditions and give the landlord an opportunity to correct. The landlord refuses, and then they may be able to hold rent.
Now, I understand if it's something like the furnace out in, December, the landlord should take care of that within 24 hours. But if it's a leak underneath the sink or something like that, how much time do they have to
And the Fit Premises Act is,
I
let's
would
stay
do it
afterward.
immediately.
Exactly, yeah.
Because I wouldn't want the damage.
Let's stay afterward and we can talk about the Fit Premises Act, because you get into the conditions of the home and there's different types of damage, or different types of notice that are required there. But if you have specific questions, we can talk about that later. Lease termination is where you're letting them know the lease isn't going to be renewed. As long as it's not for a discriminatory reason, you're fine to give that. Utah law is 15 days unless your lease is something different. You'll want to go with your lease. So if your lease is longer, don't do it if it's shorter. And the termination date is at the end of the month. So if you give a 30-day notice on June 9th, 30 days is going to be July 9th, but it carries through the end of that month. And that's something a lot of tenants get confused on. The example I always give is a contract, a lease is in a monthly chunk, right? Monthly rent, paid on the first of the month, and it carries them through the end. That's not, you don't prorate it at the end of the lease normally. The example I give is go into Walmart, pick up a Snicker bar, eat half of it, and try to pay for half of it, and let me know how that works for you. I only used half. I left halfway through the month, so I'm not going to pay for the whole month. That's not how Snickers bar works, and that's not how contracts work either for your lease. You can work something out if you'd like, but that's Utah law. Okay, paper eviction and opinion eviction. This is me talking, this isn't under the law, but I just want you to focus on what evidence the judge is going to use to decide their case. Are they going to focus on papers or opinions? In a paper eviction, I tell the judge, Your Honor, look at these papers. They're what show that we're entitled to an eviction. In an opinion eviction, I have to tell the judge, Your Honor, listen to my client and ignore the tenant. Then the judge has to listen to both sides and make a decision. With a paper eviction, it doesn't require any opinions or major testimony, and the opinion eviction is the exact opposite. I had a case where the judge told my client, and I honestly couldn't disagree with the judge. He told my client, I hear what you're saying, I'm just telling you I don't believe you. And some things came out in court that had not been discussed with me, and that I couldn't say the judge was wrong. I think he made a decent decision on it. Types of paper evictions are typically a 3-day pair quit and the no-cause lease termination if you're just terminating their monthly lease. Opinion eviction notices are basically everything else. Now here's what please pay attention to this one. A good landlord will help me turn an opinion eviction into a paper eviction. Please do these things. Take pictures, keep a log of the violations, get witness statements, bring a witness for inspections, avoid verbal communications with problem tenants. You don't have to avoid all verbal communications, but when you think, this might be starting to head south, make it a little bit more official, because you can turn an opinion eviction into a paper eviction with letters, documents, pictures. Those help a lot more to take it out of the he said, she said battle.
Sending written letters, second emails?
Yes, I'm fine with that. Just so it's very clear, it's so easy for somebody to say, that's not what I said. Well, there's no documentation of that unless somebody's recording it. But in an email, I prefer email over text. It's just a lot easier to handle emails. But a text message as well. But you get these, I would much rather email with people. Here's a few examples of the opinion evictions. They're not nearly as common as evictions for non-payment. And the landlord bears the burden of proof. So that is your responsibility to be able to prove the grounds for the eviction. With a nuisance, that's the statute I've highlighted in red, the most important part. A nuisance is when somebody interferes with the comfortable enjoyment of life or property. Sounds like an attorney wrote it, isn't it? But it's basically they're creating such a ruckus and they're bothering other people to where they can't quietly enjoy their property. That's basically what it is. Two types, criminal and non-criminal. The criminal is much more serious, and we'll talk about it in a second, but a criminal nuisance will entitle you to an emergency eviction hearing if you have to go that route. A non-criminal nuisance is not as severe, and that first one is the most common one that you're going to deal with. They're just bugging other people to where they can't quietly enjoy their property. If you do an eviction notice on nuisance, you want to make sure that you're identifying criminal versus, if it's criminal, definitely identify it, and then state the facts supporting the claim for the nuisance.
What if it's a misdemeanor?
If it's a misdemeanor, it wouldn't, I guess there are certain misdemeanors would be a criminal nuisance. Threatening violence against another, so assault or battery could be considered a criminal nuisance. If it's not, then you still probably have the non-criminal nuisance.
What about like barking dogs or loud music, late parties?
That's probably the stereotypical example of a nuisance, where their activity, whether it's guests coming in and out all the time or loud parties, noise, that's probably the most typical type of nuisance that you'll see. A tenant at will, this is something that a lot of people get confused on. A tenant at will is somebody that doesn't have any agreement or right to occupy the property. Here's some examples. A friend moves in, your tenant moves in a friend, and now they won't leave. Or the lease expires and it doesn't automatically renew, so now their lease rights have expired. Or an owner investor purchases the home at a foreclosure. That makes them a tenant at will, where now their rights to occupy the property have expired. The questions to ask that I think you should ask to determine a tenant at will: when did they move in and when did you find out? I have a lot of clients that will call and say, oh, I've got a tenant at will. Well, how long have they lived there? 6 months. When did you find out about it? 5.5 months ago. What have you been doing for the last 5.5 months minus 1 day? Well, I didn't care too much. Okay, well, they have an argument that they're now living there with your permission. They might not be a tenant at will. Have they been paying rent? Oh yeah, they paid rent, but here's the key. We don't have a written lease. We don't have a lease in place, and so they're a tenant at will. No, you have an oral lease in place, and that's a dangerous situation to be in. If somebody's living there with your permission, there's a lease in place. It's an oral lease, and under Utah law, an oral lease is just as enforceable as a written lease, but it's a lot harder to prove what an oral lease is. So you want to be careful with this.
How do you really establish the fact that the person is actually living there? Because most of the time they tell you, oh, I'm just visiting. But you know that they are there, but you can't really prove it.
You're going to get the answer that I give a client every now and then. The only person that can tell you a real solid answer is the judge.
Oh.
That's not what you want to hear, because that's gray area. Are they living there? Are they residing there as a tenant?
But you know they are, because if you see them...
It's going to be, well, if I had enough time, I could flip back to how to turn an opinion eviction into a paper eviction. If you're worried about it, start keeping a log. There was a house in my neighborhood that was, the people were an absolute nuisance, and so the entire neighborhood was keeping track of license plates. They had way too many people living in the house. They kept track of license plates. And I'll tell you, if you go into the police and say, oh, they've got too many people there, well, how do you know that? Well, we see them all the time. They're probably not going to listen to you. But when you go in, and it worked itself out before we had to do this, but if you go in with a log of a month's worth of license plate numbers, they're going to listen to you, and they're going to say, yeah, it sounds like...
Actually, I have a camera around, so I could use that as evidence.
Yeah. And that's a gray area. There's not a real hard, fast answer to be able to give you there.
On your screen there, where it talks about owner investor purchased the home by foreclosure, are you talking about someone who owned the home before, and so you bought it as an investment property, and they're not moving out, so then their tenants are held?
I'm talking about if the house goes through a foreclosure, and at the foreclosure sale, at the trust, you purchase the property from the trustee, and you're now the new owner because of the foreclosure sale.
But who's in the house?
The prior owner.
The prior owner was still in the house, not
Yes.
moving out?
Yeah, and we can, that's maybe another question for afterwards. Protecting Tenants at Foreclosure Act, if it's the prior owner, they're the tenant at will. If it's the prior owner's tenant, it was an investment property and there are tenants there, the Protecting Tenants at Foreclosure Act is a nightmare and it's ridiculous. But you want to be careful because they are not tenants at will. The lease actually survives the foreclosure. That's why December 31st this year will be a good day because it's got a sunset provision, but I would not, they've already extended it once. I wouldn't be surprised if that got extended again, and I wish they'd modify theirs.
So if an owner sells his a unit that he owns and he has tenants in it, isn't that contract with the tenant still binding until it expires?
Are you cheating and looking ahead?
No, I'm just asking.
What if an investor purchases a home through a regular process, not a foreclosure sale, and wants to have the home vacant? Does the sale make them a tenant at will? No. It's the foreclosure sale that with the prior owner in there, that's what trumps and wipes out that lease. But if it's a voluntary sale, including a deed in lieu of foreclosure, then that lease would survive that transfer. What if there's no written lease, nothing is in writing, or are they tenants at will? We'd already talked about this. Probably not. It doesn't matter if it's an oral contract. It's just as important as a written contract. So, one example with opinion evictions, you have an eviction event, you give a 3-day eviction notice, and in this situation, you do a 3-day notice for nuisance and a 3-day for lease violations. And then you either cure and they become their perfect tenants, or they quit. And here's where you watch this close. Did you see the angel ascend? So, but the question is when can you eliminate their opportunity to cure? When can you say, here's your 3-day quit, not 3-day pay or quit or cure or quit, 3-day notice to quit? When can you do that? They can cure for basic lease violations and the tenant will, but here's one of the problems. If the tenant can cure, the landlord has to prove 2 separate violations. One, to say, here's your eviction notice. But then they have to prove that they didn't fix the problems, and so they have to find another violation to justify the eviction. So you want to be careful. And there's a list of things that I think the landlord has an argument that they can't cure those, especially for major violations or things that can't be cured within 3 days. For me, use your lease to define what they cannot cure. My father's a real estate broker down in Price, and he has his lease that he's been using for 20 years. And he was so proud of it, and I'd been working on my lease. He called me one day and he said, I've got a tenant that has pets and they're smoking. What do I do? And I said, well, it's a 3, and I said, you got to give an eviction notice. And I just smiled and I said, Dad, whose lease did you use? Because I'd been kind of saying, hey, why don't I use mine? And he was really proud, and he said, well, I used my lease. I said, oh man, I wish you would have used mine. Well, why is that? Because in my lease it says that pets and smoking are violations of the lease that cannot be brought into compliance and subject the tenant to a 3-day notice to vacate. So I said, Dad, you have to catch them twice. Once for the eviction notice, once for the lawsuit. With this one, you got an argument that it's just once for the eviction notice. And then if they're not out in 3 days, then we can move on with the eviction.
What is the Utah Apartment Association?
I don't think it has that specific provision in there. It's very strict. I know I'm biased with mine, right? So I'll just say mine and the UAA's is they're tied for first and second.
Sir?
Yes.
How do we get one of your?
It's on my website. It's free.
Yeah.
UtahEvictionLaw.com, and we have some free handouts. Grab some on the way out. It's free. But for me, it's use a good lease. The UAA's documents are great, and so either one.
I wouldn't sign it because I don't understand it. It's so complicated and it's not.
It's like an attorney. It's like an attorney wrote it.
To understand it.
Well, and my lease it does.
It
There's a lot
protects
of.
us, but how do we explain to them
Yeah, they
what
wanna
it
know what
says
it is.
when we don't know ourselves?
And that's a careful reading of any lease. And you, in all honesty, you might have some questions about my lease as well in that regard, because I try to. I mean.
That's why we're here.
Yeah. But if you have questions, just let me know. But I think use a good forms. You've got a couple of good options that are available to you. Talk a minute about abandonment. Abandonment is presumed in these 3 situations. You've got to prove all 3 of them. The tenant's left without notifying you where they're going to be. There's no reasonable evidence that they're occupying the property. And then third, pay attention to whether their possessions are still on the property. If they've been removed, it's abandoned when rent is 1 day past due. There cannot be an abandonment presumed, right? So it's not guaranteed, but normally you can't have an abandoned property that's been paid for. But if it's 1 day late on rent, then it's abandoned. If all their possessions are still there, you've got to wait till it's 15 days late, and then it can be.
Can you count stuff in the refrigerator?
What was that?
Can you count their refrigerator contents as something that's still been left?
Yes.
It's still their possession.
I had a client that called me and said, I think it's abandoned, I haven't heard anything, and I said, well, what's in there? They did a 24-hour notice of inspection, and they went in. And as he's walking through the house, he's like, well, they've got several things here. They could be living here, but I'd be surprised. And I said, well, open up the fridge. And he opened it up, and there was a couple of gallons of milk that had been expired for 3 weeks or so. I said, those types of things I think can help. But yeah, I think you take it as the totality of the circumstances as far as what's there. What notice is required to declare the property abandoned? There isn't any. But please still do it. Police will often side with the tenant if it's not clear, and even when it is clear, they'll still side with the tenant. So you want to be careful. The horror story I give on this one is, I had a client she's a licensed family therapist. The property was clearly abandoned, hadn't heard anything for a while. They were more than 15 days late on the rent. The lawn started getting long, so she was mowing it, and a couple of times after mowing it, one of the neighbors came home like, hey, have you seen the Smiths? I hope none of you guys have the last name Smith. I picked one. Have you seen the Smiths? And the neighbor said, I haven't seen him for a couple of weeks. I saw him packing up a car, but they've been gone for a while. That's abandonment. So she did what the law allows. She removed their stuff carefully and securely, put it in a storage unit, re-rented it, got a new tenant in there. The law specifically says you can do that. Well, the tenant got back from her grandmother's funeral in Arizona and knocks on the door. It was a really awkward conversation there. And the old tenant called the police, and the police threatened to throw my client in jail for trespassing and criminal trespassing and theft. What was that?
The new tenant? Who is being thrown to jail? The new tenant?
No, the landlord, sorry. The landlord, because the landlord was the one that removed it. So the police said, well, you removed it, so that's theft. And you had to go in to remove it, so that's trespassing. And the police officer said, unless you meet me at the storage unit and open it up, you're going to jail today. And so she did, and the police officer wouldn't back off. And so I got on the phone with him, and I said, what's going on? This is abandoned. Well, no, we're going to be charging her with this. And I said, well, why? And his only answer that he could really give was, well, she didn't give any notice of abandonment. And I said, was there anything else? No. If she would have done that, I think I would have been okay with it. And I said, officer, read the statute. There's no notice of property abandonment. There's some personal property abandonment issues now that have just recently come out, but you don't have to give a declaration of abandonment for the property. And so I said, talk with your legal department, because I'd be happy to explain that to a judge and get it dismissed. And they backed off, but they were very clearly wrong, but a notice of abandonment would have helped her.
So just a picture of on the door that says this place is abandoned is all we need, right?
I have a declaration of abandonment that's on my website. Post it on there, take a picture, give it a day or two. There's not any requirement of it, so how long do you leave it on there?
5 minutes.
Well, maybe 7, no. I'd give them some time to legitimately claim that it's abandoned. I mean, if it's abandoned, usually giving them a few extra days isn't going to be that big of a deal, so maybe give them through a weekend. And if they don't call you and object and say it's not abandoned, then I think it's going to be abandoned. If they do call you and object, then say, okay, hey, great, you remember how June's rent still isn't paid? Let's talk. So it gives you an opportunity to communicate.
So if I understood your story correctly, this gal went to her grandmother's funeral, and she hadn't paid her rent before she left. So one day afterwards, she went and posted. And,
well, it would have been 15 days, because they still had all their stuff there.
oh, okay.
And it was more than 15 days late.
So she didn't bother trying to call her on the telephone?
She tried. She couldn't get a hold of her. Wasn't responding. And the cop asked me, he said, well, how would you feel if you left to go on vacation or went to a funeral and you came back and everything was gone? And I said, well, first of all, I'd be really mad if I'd paid my rent and that happened. But that's one of the conditions of the statute. So you really, really please be careful with abandonment, though. An eviction is when the judge says you can change the locks. An abandonment is when you decide to change the locks. And a judge can disagree with you, so you want to be careful. And I found this on the internet. You want to know what a botched abandonment case looks like? My client that was getting a lot of pressure from the police, I know that that's how she felt. She thinks everything's going fine. running into a little bit of a pothole, and it can be very difficult and scary. You definitely want to be careful with these. One more time. I would have thrown the chicken and then been dinner.
Just a quick review. What is the relationship between that they have not paid their rent and abandonment? That's more evidence that they've abandoned?
If their possessions are removed, they have to be 1 day late on the rent. So if they've moved out and it's vacant, as soon as they're 1 day late on the rent, then it's abandoned. If their possessions are still there, then the law says, you know, give them some time. Maybe they have disappeared to a funeral or whatever, so they want to make sure that it's abandoned, so there's a 15-day waiting period there.
What if you, say, serve papers for an eviction related to a nuisance, there's no payment involved, payment issues, and it appears they've moved? When can you change the law?
Remember the 3 steps. First step is serve eviction notices. I'd do a nuisance notice and I'd do an abandonment notice and just see what kind of response you get. And as long as you're satisfying this definition of the statute.
Well, I mean, you've served the
nuisance.
The nuisance notice. You filed the lawsuit. Paper's been served, and so they say, well, I guess I better leave, and they just leave. And of course, they don't tell you that they're leaving. When can you?
In that situation where you file the case and it's been served, those are all the tricky parts of doing an eviction. And so I would just get an eviction order. If they're served with, that's really what triggers and starts the ball rolling with an eviction, is service of those court papers. So I wouldn't go abandonment on that situation. I would get the eviction order.
Okay, but if they've moved out, will the judge go ahead and rule on the eviction?
Typically, yes. I mean, that's kind of a case-by-case basis, but typically, yes. I would still recommend, again, because down at the bottom, stick with the eviction where the judge is saying, yes, landlord, you can change the locks.
Okay.
That's definitely the safer route to go. One more time. No, I'm kidding. Treble damages. They're defined here, and it allows the landlord to triple certain damages that are assessed in the eviction. Here's the tricky part, though. The winner is entitled to treble damages. So you want to make sure that you're the landlord and that you're winning, because if the tenant wins, the tenant gets to triple their damages. And I had a client call us a year ago or so now. The landlord wasn't paid, so they moved all the tenant's personal items out on the lawn. It rained later that day. The tenant claimed that there was $30,000 in personal effects that were ruined. What's 30,000 times 3? $90,000 in treble damages. And I told the client, I said, I'd be happy to try to whittle down that $30,000, but then you're going to be paying my attorney's fees, their damages, and their treble damages. So you definitely want to be careful with evictions. Whoever does it right is entitled to treble damages.
Well, you're entitled to treble damages, but are you going to get?
That's a question for him. He's going to, yeah.
He talked about that.
Yeah. Eviction hearings and how to get an expedited eviction. Under Utah law, an eviction trial has to be held within 60 days of service of the summons and complaint. On average, we're 2 to 3 weeks to do an eviction. So how do you get an expedited eviction? 4 options. Number 1 is non-payment of rent. If they don't dispute it, then you get an expedited eviction in any eviction. But if it's for non-payment of rent and they fight it, you get a 10-day hearing to prove your case. If it's for criminal nuisance, you get that same 10-day hearing. Post-foreclosure eviction, so if you purchased the house out of foreclosure, gave them a 5-day tenant at will, then you get that 10-day hearing. And then here's the catch-all. The 4th option is the landlord pays a possession bond. And that's available in basically all the other cases. And a hearing on a bond should be held within 3 days. So what's a possession bond? It's a deposit paid by the landlord to the court. It's used to speed up the eviction. It's basically similar to a security deposit. If the landlord wins, it's refunded. If the landlord loses, then the tenant can collect that judgment. So it is at risk. There are certain cases where the tenant can post a counter bond. We recently had a case where, and the standards for each bond are different, right, by the way. We got our bond set at $490, and we got the tenant's bond set at $8,000. So we had $490 at risk, they had $8,000 at risk. How do you collect treble damages? Well, you do that, You go to trial, you get a $31,000 judgment, which is what we got, and then we got $8,000 right off the bat because they had posted a counter bond, and we had our $490 refunded back to us. So, what's the usual amount of the bond? It's normally 2 months of rent because the trial has to be held within 2 months. When should you consider a possession bond? When you're outside those 3 emergency cases, or or if it's a commercial eviction. You're not entitled to those expedited procedures in a commercial eviction. The tenant's options: within 3 days, they have to either vacate, request a hearing, file a counter bond, or pay the entire amount owed. And if it's for a nuisance, that 4th option is not there. You can't pay your way out of a lease violation or a nuisance. Final test. And by the way, this is based on my neighbor in law school. Druggy Dan signed a year-long lease, and put your papers down, by the way. The answers are in there, don't cheat. So Druggy Dan signed a year-long lease 15 months ago, and he's been a problem ever since. The neighbors are complaining constantly about Dan using drugs, and you found a police report showing Dan was arrested for meth. Dan also had his girlfriend, Martha Methhead, move in with him without receiving your permission. So that's what you're dealing with. What eviction notices should you give?
Nuisance.
Okay? Eviction notices, remember, there are multiple that we can do here.
15 days.
Comply or vacate.
What was that?
Comply or vacate.
Comply or vacate if they're lease violations. You had one?
15 days termination.
Yes, either 15 or 30, depending on what your lease says. But please, that one I want at the top of the list. Remember the paper eviction, opinion evictions? It's a lot easier to prove that we gave a 30-day notice than to prove that he's dealing drugs. Anything else?
Subleasing.
Thank you. That's a good one. Assigning or subleasing. And what about Martha? Nobody mentioned Martha. You need to pay attention to who you're giving eviction notices to. I think we got all of them for Dan, Colonel Ack maybe. So we got all the notices for Dan, but don't forget Martha. I would give Martha, she's definitely a tenant at will, right? Moved in without permission. She's also an assignee of the lease, so you're a sublet or the tenant, or sublessee. So I would list her on her own eviction notices as well. And again, if we took this one to court, well, Dan, let me fan out your 5 or 6, 5 eviction notices. And Martha, I don't even have a lease with you. I only need 2 eviction notices. But that gives me a lot of options to talk with Dan and Martha about how to handle this. If you end up having to file for eviction, who are the defendants? Both of them. But the better answer is whoever you listed on the eviction notice. I can't add people as a defendant in an eviction unless you give me an eviction notice with their name on it. So you want to make sure you're listing them in your notice.
And what if you don't know their name?
That's a problem. I would try to figure it out.
We put their license plate number on it?
Try to figure it out. One of the advantages, and I'm just dealing with this in a case that comes up occasionally, we're doing an eviction where they've sublet it to somebody else and we didn't know who they were at the time of the eviction notice and when we filed. Under Utah law, they're in violation, they're subject to an eviction if they remain in possession of the property through them or any subtenant. And so if I can name the primary tenant, if I only know Druggy Dan's name, defendant number 1 is Druggy Dan. We always put John and Jane Doe's 1 through 5, and so Martha Methhead would be the Jane Doe number 1. But I didn't have her name, and so my argument to the court is, Your Honor, I really just need an eviction order in Druggy Dan's name because it will evict him and anybody that's occupying the property under him. And the only reason Martha's in there is because of Dan. She doesn't have any other independent right to be there, so an eviction order on Dan would clear the house. The last one, change the scenario. Dan is 6 months into his 12-month lease. What do? Basically the exact same situation, except you've got to take out that no-cause notice. But please build your case. Do what you can to take it from an opinion eviction into a paper eviction.
It would seem to me, if there's a police report, that would be a 3-day nuisance right there, wouldn't it? So
Yes.
You would need the other one?
The other, which one?
The 15-day to vacate.
The answer is legally yes, but from a practical standpoint, I had another case where the landlord, and it's another family therapist. I don't know why family therapists have so many problems that attorneys have to fix for them. But I had another case where it was a duplex. The landlord lived in one side, the tenant lived in the other. The tenant was being difficult, and the landlord went over and started talking to him. It escalated so quickly, and I know this client, I've actually kept in contact with him. I firmly believe their story. It escalated so quickly, and the tenant punched the landlord and knocked a tooth out. And the landlord said, can I use his name? Geez, Sam, call the police. And the landlord let the tenant call the police. And so who got to tell the story first to the police? The tenant. So then they called me and said, I want to evict him. Well, that's a criminal act. And that's you can consider that a nuisance. So they said, well, what should I do? And I said, well, it's your word against his on a nuisance or criminal act, but he can't argue about a 15-day notice. And so can you hold out on it? Because he's going to fight this tooth and nail. And we did. Yeah. We did, and we gave him it was a 30-day notice. And when he got in front of the judge, he had this big, long laundry list of all the fight and everything else that happened, including what did he put in his affidavit? I should bring that. His crazy, the landlord used crazy ninja moves. That's exactly what it said. He brought all this to court, and my point was, Your Honor, I've got a royal flush here. I have a 30-day notice that he didn't comply with. So even if he's correct here, which we dispute, even if he's correct on everything else, we terminated his lease. He's done. We got him out. So congratulations, you graduated from the Utah Eviction Law School of Hard Knocks. Being a landlord is all about experience. You remember, you just have these years of experience, and if you don't, the UAA is great at helping you with that. They've got a lot of different resources and things to help you have that experience, and we have a lot of experience as well. Nobody ever calls me to tell me how great their tenants are. I always only deal with the problems. But if you ever have any questions or problems, please feel free to give us a call.
Every tenant is different. They bring a whole bunch of different problems every time you get a new one.
Yep, they do. And by the way, I hope I'm not sounding too negative. I firmly believe work with your tenants, right? That's the best option. But if you have one where they just aren't working with you, then we can help out. But when we're all done, Brian's going to come talk to you about collections, but stick around for some war stories and questions. During war stories, names are normally changed to protect the innocent, but since these guys aren't innocent, we'll tell you the court docket. You can go look these up. Anyway, I think that covers just about everything, so thank you.
All right, my name is Brian Booth. I work at a law firm called Fetzer, Simonson, Booth & Jenkins. I'm going to talk about